Did you know that just because your client was awarded property in a divorce decree doesn't necessarily mean that the ex-spouse doesn't still have to sign at closing? I know, super frustrating, annoying, time-consuming, and nobody wants to hear it. However, unless the final divorce decree has specific language put in it by the judge that says it divests the ownership interest from the ex-spouse who's not supposed to own the property to the ex-spouse who is supposed to own the property, then they both still have ownership interest on record. So how do we resolve that? Either the ex-spouse who's not supposed to have ownership interest signs a quitclaim deed over to the spouse, typically your client, who is supposed to own the property outright, and we get that quitclaim deed recorded before the new deed for closing. Or they can come to closing and sign, or they can stop by at any time, not at the same time as your client's spouse, and sign the warranty deed that's going to be signed in conjunction with closing. They can just swing by and sign at any time. Either way, we've got to have their signature. So I get asked a lot of times when this scenario pops up, well, what if they won't sign? Well, if they won't sign, then they're in contempt of court. And so what that means is they can be prosecuted not just civilly but also criminally. So my suggestion is typically to your client or the spouse that has the property is to get with their divorce attorney, have their divorce attorney contact their ex-spouse's divorce attorney, and that divorce attorney can figure out how this spouse is going to sign the deed, because nobody wants to deal with a contempt of court charge. Typically it gets resolved. It's an extra step. It's a little frustrating to everybody, but I just wanted to pass along that important information because it's good to know.